Hi, my name is Michael Jurek, and my case study is going to be over the District of Columbia versus Heller, which was argued back in 2008. It's a very big case regarding the Second Amendment and its private ownership versus militia, and it goes a little under the radar because I believe the repercussions never took place because Heller ended up winning versus the District of Columbia. But I hear I'll dive in a little bit about just what happened in case you've never heard of it. So, Washington D.C. City Council, hoping to reduce the crime rate in the city, passed the Firearms Control Regulations Act of 1975, which effectively banned gun ownership in the district. Now, the act originally prohibited D.C. residents from possessing handguns, but made some exceptions for police officers and security guards, of course. It also prohibited residents from keeping firearms in their homes without licenses, which Texas, of course, we have that as well, and require that any licensed firearm kept in the home either be unloaded and disassembled or fitted with a trigger lock. Now, I find that interesting because it's defeating kind of the purpose of the firearm itself, which if I was to compare it to, say, a video game station, or I don't know, just something that's a little more complex to take apart, maybe like a computer. I know it's very different from a gun, but disassembling it and unplugging it from the wall and taking the parts, unscrewing everything, it defeats the whole purpose of actually owning and maintaining something that you purchased with your money and your hard work. So kind of interesting. And then trigger lock as well. That's safety. If you're owning a gun for safety purposes, it's smart to have that. If you were traveling or there's children around, you have it in a certain place. It's all depending. But just the fact that they try to have private gun owners unload and disassemble their own guns in their own house is kind of It's just mind-boggling to me. So a man by the name of Dick Heller, who was working as a special police officer in Washington, D.C., as a part of his employment, obviously he was allowed to carry a handgun while at work. But wanting to keep a handgun in his home after hours, he applied for a license to do so, but the District of Columbia actually denied his application. Now, Dick Heller sued the District of Columbia for violating his Second Amendment rights, which is where this whole thing comes into play. This is very interesting. Based on it, the district court found that the Second Amendment does not create an individual right to gun ownership. But unrelated to that, the service of an organized militia, like police, security guards, National Guard, and thus the district court dismissed Heller's complaint. So it went up to the Court of Appeals. They did find that the Second Amendment does create an individual right to gun ownership, and they actually reversed the lower court's decision. So, they have that in the Court of Appeals, and they reversed it. They completely did a 180 on them. Now, the United States Supreme Court, they granted certiorari. And the issue on appeal was whether the D.C. law prohibiting the possession of handguns in the district or usable firearms in a home violated the Second Amendment to the United States Constitution. In a very, very tight decision, 5-4 decision, the Supreme Court held that the District of Columbia's law restricting Heller's ability to possess a firearm and altogether prohibiting him from keeping a handgun in his home violated his Second Amendment rights because he wasn't, mentally ill, he wasn't a criminal. Justice Scalia, writing for the majority, said the Second Amendment protected his right to possess a firearm, even if such possession was unconnected with service in the militia. So just because he was a security guard or police officer, that's totally unconnected to whether or not he can own it in his own home. Scalia engaged in a deep textual analysis and concluded that the Second Amendment's reference to the need for a well-ordered militia was only an introductory clause, kind of indicating the amendment's purpose. But it didn't limit, the right to bear arms guaranteed in the amendment. Scalia concluded that there was nothing in the legislative history of the Constitution, nor state constitutions, sorry, I'm having trouble saying that, or nor even the Founding Fathers intended to limit the gun ownership, that they didn't tend to limit the gun ownership solely for militia purposes. The majority did allow that the states must be free to regulate who can own firearms in order to address certain safety concerns. An example of that a state might restrict convicted felons or the mentally ill from gun ownership, which is what I mentioned earlier. But Heller did not fall into one of those narrow categories of gun owners who might threaten public safety, nor the court found the District of Columbia's prohibition on gun ownership to be overly broad and deemed it unconstitutional. Justice Stevens dissented, relying on the court's decision in the United States versus Miller. In that case, the court held that it was unlawful for two men to possess a sawed-off shotgun because their reasons for doing so bore no relationship to the purpose of preserving a well-regulated militia. Justice Stevens alleged that neither the text of the amendment nor the debate surrounding its passage indicated an interest in limiting the legislator's ability to regulate the private civilian uses of firearms. Rather, he explained that the individual's rights to keep and bear arms was designed to be solely for the purpose of preserving a well-regulated militia. Because Heller sought to own a handgun for self-defense and not as a member of a militia, because he was already part of one as his job, Stevens contended that the District of Columbia may restrict such ownership without infringing on his Second Amendment rights. In his dissent, Justice Breyer asserted that the District of Columbia laws did not violate Heller's Second Amendment rights because the Second Amendment protection of the right to bear arms is not absolute, which I think is interesting because, it says they shall not be infringed, and it says that in the amendment itself, but okay. And he also said that it was a subject to reasonable restrictions. He also explained that the court must balance the burden of law that it may place on an individual's right to bear arms with the importance of the state's interest in doing so, concluding that the District of Columbia's law did not unreasonably interfere with Heller's rights of self-defense because its purpose was to combat the presence of handguns in high-crime urban areas. And that interest was important enough to justify the restrictions, which makes sense because you have to put restrictions on things that are as important and big of an issue as guns can be. In the wrong hand, the gun in a bad man's hands will end up doing bad things. The gun in the hands of a good man who is a responsible gun owner can be good for self-defense, for hunting, for whatever purpose, but depending on whose hands it is, mentally ill or convicted felon, the category of good and bad, it's so black and white. It's all about whose hands they fall into. So the District of Columbia versus Heller is a very, very important Supreme Court case, and it's really kind of the first Supreme Court case to explore the meaning of the Second Amendment since the United States versus Miller in 1939. Heller really set the stage for the 2010 case in McDonald versus Chicago, in which the Supreme Court expressly held that the Second Amendment was incorporated against the states. Really fascinating. Heller still is kind of an activist for the Second Amendment movement, and even today it's a big conversation going on, and how we can keep the guns out of the hands of bad men. The states have to regulate, and you have to be careful where you're buying your guns, who you're selling them to, and be a responsible gun owner. Just like I am. Proud American, proud gun owner, responsible. Thank you for listening to my case study. If you listened, I hope you enjoyed it. I'd recommend you go and even do more in research because it's fascinating, all the details you can dive into. Thank you again, and goodbye.